is hopefully a fun one. We make it very interactive. I don't like to give a lot of people a lot of time to talk, so interrupt them if you feel like it. So my name is Dan Trevas. I've had a real privilege to be the chair of the Media Law Committee here at the Bar Association, but I used to be a journalist. Then I became a lawyer, and now I work in public relations. So I tell people I'm trying to become the most hated person in Ohio, but it's getting there. But one thing, this was brought to me as an idea 2 years ago, and I said, no, there's no way you could just really just vent about what you hate about people. And I said, well, kind of, because the real intent of it is, yes, we're going to couch it that way, but really it's a hope to be a learning experience. Because there is little things that when you go to interview a lawyer, and sometimes they feel off-putting, it's not because they're jerks, well they might be, but there's some reason to it. And when you go to talk to a reporter, it's not because they're just an arrogant know-it-all. There's a little bit of method to their madness. So the idea was if we could talk and understand each other a little bit more about what we're trying to do, what we're obligated to do, what we need to do to get our jobs done, that we might all get along. So I thought I'd bring a great panel here, and I'm going to let them talk a little bit about themselves, and then we're going to go around with the things they hate about each other, and Professor Smith here is going to help us sort it out a little bit. So why don't I start with Jay Milano. Jay, you want to go first?
I guess. My name is Jay Milano. I'm a lawyer in Cleveland. I've been a lawyer now for 30-some years. I have a trial practice, and I have had cases in the media like all of us. That's my practice. Actually, I'm sorry, I have to say this. I also hold the dubious distinction of having called the Pope a racketeer on 60 Minutes.
That's right.
So I have some experience in being stupid. Or brave, depending on your point of view.
My name is Jim Mccarty. I've been at the Plain Dealer for 22 years, in the business for about 30 years. Jay and I have worked on many stories through the years. Most in my mind.
Together and opposing each other.
Yes. Most of us, we've worked on some big cases. I forget half of them, but they were big at the time. And I don't hate lawyers. I like lawyers. I have 3 brothers who are lawyers and 2 sister-in-laws, and some of my best friends are lawyers. But and I've been covering the law since I got into the business, so it's like second nature for me.
Great. Tip.
Well, I've been a journalist either as a practicing journalist or a professor of journalism for 46 years. I'm by far the oldest one on this panel. And a lawyer for 36 years of that 46. So I've worked on both sides. And my only complaint about this panel is that I want more than just 5 things that I hate about journalists and lawyers.
Wow. Because most of what it's usually just one thing you really, really, really hate. So with that, I'm going to let Jim. I'll just make a quick aside. When I was a print reporter almost all of my time, and sometimes you're in with television reporters, and sometimes they are watching you, and covering stuff jointly, and sometimes they're broadcasting it. And we do look like snakes when we're in a huddle, with the governor or something like that. We're jumping all over him. But just because we're acting like it doesn't mean we are. That's our job. So he might not hate lawyers, but there's certainly certain things about how they go about their day that he hates. So give us your number one thing you hate about lawyers practicing law. How about that, Jim? Is that a better way to couch it?
I can kick things up. What was the citation you gave, the 3.6 citation?
Rule 3.6 of trial publicity.
Trial publicity. I don't know if that applies to 2013 journalism and law. Jay and I were just chatting before we got started here. I really can't remember the last change of venue that we've had in Cuyahoga County. I mean, there may have been some, but most of the time, it is a very high bar to reach for the defense lawyers to move their case out of the county. I have, through the years, traveled to different counties to cover trials that had been moved, but mostly in smaller counties. I mean, it's pretty tough. I mean, when they sit that panel of 50 or 100 potential jurors down and start talking about, well, what have you read, seen on TV, and have you formed an opinion, and things like that. We're sometimes brought back to earth by how little of our work, reached the readers, and how little of the TV people and radio people reached their listeners and watchers. So that in mind, I get to my biggest pet peeve. The thing I hate about lawyers, not lawyers, but the thing they do is, of course, is the no comment. And usually it's in a kind way. It's my policy not to comment on a pending case. I've probably heard that hundreds of times. And I can never understand it, because the other side is going wild. I mean, if it's a criminal case, we have indictments, we have affidavits, we have mugshots, we have police reports, we have outraged comments from the prosecutor. Depending on the prosecutor, we have one who just loves to be heard and seen and listened to in Cuyahoga County now. But
Wait, you're a reporter. Say who it is, who, what. It's Timothy J. McGinty.
Timothy?
And he has no filters. And I will probably quote him before we're done, because it has to do with publicity. So.
And he's also, from my perspective, he's the best thing that's happened to us since in the 22 years I've been in Cleveland. He's just
like taking pictures of a car wreck.
he's entertaining. He has a knack for saying, for speaking for the people. He's saying what everybody's thinking, and he says it in a West Side Cleveland tough guy characterization. So typically, this may surprise some people, but if there's an indictment, an arrest, a high-profile lawsuit that has been filed, the first call I will make will be to the lawyers and the other side. And even if I get a call back, or I hear the same. I've been doing this long enough to where I know that the receptionist or the secretary is screening calls. Is Tim Smith in his office? I'll check. I'm not sure. I mean, it's basically she's calling Tim Smith and saying, I got so-and-so from the Plain Dealer on the line. Do you want to talk to them? And I'll either get a call back from the receptionist. I'm sorry, Mr. Smith has stepped out of the office, or he'll pick up the phone. So the problem is, we get the obviously the off the record response. This is what I think about the case. Well, what good is off the record for me if I can't use it? I mean, there are ways to use off the record comments. We can go to a different source and say, this is what I'm hearing, without revealing from whom. Can you verify that? Or we'll get a sometimes not as good, not quite as bad as off the record, but something like not for attribution, or more commonly known as you didn't hear this from me, but. We can use that if we're the Washington Post or the New York Times, who routinely use sources said, or sources close to the investigation, or sources close to the defense team.
I think so we're good. So Jim's number one really is stonewalling in kind of a polite way. Either I'm not going to say anything, or I'm going to say in some way that can't let him use it, which is as valueless as saying hanging up. So with that as your one, Jay isn't really of that mode, but if you were, give me the rational reason why somebody would do why would a lawyer do what Jim doesn't like?
Well, let me follow it through. Let me try to follow through what Jim has told you from another point of view. From the lawyer's point of view. First, as a threshold, you have to look at our rules that we live by, and that is when we can speak publicly and when we can't. And the rule is a pretty basic one. It's been alluded to, 3.6, trial publicity in our rules of professional conduct. It's a paragraph. A lawyer who is participating or has participated in the investigation, litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicated proceeding in the matter. So that's the threshold. That is about as loose a rule as you can imagine. And that's where Jim started with, well, the idea of changing venue. In order to have some evidence of prejudicing in the matter, that's the same analysis that changing venue has. Has the jury heard something that would prejudice them in trying the case? Well, everything is built up that jurors hear everything all the time. We're loaded with media, so there's very little that you say at any given time that would prejudice the ultimate adjudication of the case. Now, Tim Mccarty's wonderful because he has no filters. He just talks. I've known him for 35 years, as everyone from Cleveland has, and he just never holds back. And there were quotes in everybody around the state has the internet cafe cases where they're shutting them down now, mostly because in Cuyahoga County they went after them. Well, they busted an internet cafe in Cleveland, and the assistant county prosecutor says, this underscores the fact that this is a gambling syndicate and a criminal enterprise. That he's talking about seizing $1.2 million, not the mom and pop operation that defenders of these internet cafes would have you believe. I'm going to fulfill my promise, said Timothy McGinty, to close every illegal gambling parlor and rip-off center in Cuyahoga County. Now that's pretty pejorative terms. You can't be much more pointed that I just put rotten illegal people in jail by arresting them and they'll never start up again. Well, if that kind of speech is out there, it seems that there are no rules. Now, let me offer a caveat here. It is much easier for people in power to play with lax rules than people with less power. Lack of rules, in my opinion, will always prejudice the less powerful. So just be careful if you're out there shooting your mouths off. Now, that being said, the rules are loose. You can comment. Mr. McGinty has commented. We can comment. And there is a specific rule in 3.6 that says if your opposing party says something that's particularly prejudicial, you can answer it. So you could, the lawyer in that case, could in fact have answered McGinty. But it gets much more subtle than that. And the question that lawyers then have to think about is, well, why would I comment in a case? And this is the flip side of Jim's coin, that lawyers don't comment. Well, I'll tell you why you cannot comment. You can't comment to get yourself on TV, in my opinion, or in the newspaper. Just in the last excellent thing we sat through, and I personally sat through, about juvenile cases, it was mentioned that, well, some lawyers will simply talk to the media to get their name in the paper. That is a profoundly inherent conflict, real conflict on your part. Because you want to get your name in there, not necessarily for the idea that you're going to help your client, but to help yourself. And there are a bunch of us on the lawyer's side of this who only have one client ourselves. And that is a wrong and improper way to be. The flip side of the coin is that Mr. Mccarty and the media can't go after stories or after stories in such a way that they're only going for sensationalism or clicks or for ratings on TV. So we all have to do that self-examination. But then it still gets you to, why would a lawyer talk to the press? Well, you would talk to the press if you were answering Mr. McGinty in something like this, a specific story. You would answer then. You would also answer in the media if something systemic had happened. If it was part of a pattern that was going on, keeping in the criminal context because that's where this started, there was some pattern of government going on and you wanted to comment on it because the public had the right to know that this is part of a broader issue. And you might comment about your case if there are, again, these specific instances about the case. But you got to be careful as to why you want to comment, and you also have to be careful about this. Tim Mccarty is the Cleveland Plain Dealers, and I don't mean to beat Tim Mccarty up. He's not a bad man, a prosecutor. He's just a little crazy. But he, the main source of Jim's newspaper for criminal events is the Cuyahoga County Prosecutor's Office. That is their main source, and they have an inherent interest in having him comment. As Jim says, he's the best commenter going. But also, all the news that comes out about criminal cases comes first from the U.S. attorneys and the county prosecutor's office. As the defense side of it, or as the less powerful side in civil cases, you know, be careful about what you say, because again, you are the less powerful. Why then, what are the rules then for you to comment? And this gets to, you got your reasons, you got a good reasons, you called, you're gonna talk to Jim. Well, from the lawyer's point of view, there are these rules that are important to you. Jim alluded to them. What is on the record or off the record? What is for background? What can you say, what can't you say? Well, and shut me up anytime you want to say.
Okay. So right there, so I'll start there.
I wish I would have never said it.
No, I love it right there. I'm sorry, because I think Tim could do that, and that way you could hold a little bit, because I think I want him to hit from both parts, because he made some great points. First of all, what do you do? I mean, there are some cautions, I think, to the journalist if one side tells you everything and the other side's quiet. I mean, you want to probably think about balancing a story. It's like, I'm not going to be vindictive because this person didn't tell me something, so I'm just writing one side. The other point, too, is the awareness of attorneys to do just what Jay said, is that to think about if they should be scouting for pejorative information and responding. So I want a little bit about some cautionary tales on both sides, and also from your side, how do you perceive for the record, off the record, a little bit?
There's a larger issue here that Jay is alluding to and Jim dealt with directly, and that is the balance of this, all of this information. You get everything from the prosecutor's side. I am going after the world's worst person, and I've now got him in my sights. And the defense lawyer is saying, geez, I think I just keep my mouth shut. But the problem is that the perception has been already now firmly lodged in the public's mind that the prosecutor's right. You think about this, and you do this in jury selection. You see somebody pulled over on the side of the road, cops behind him with a blue light. What's the first thing you think of? What did they do wrong? Well, let me tell you, under our law, they didn't do anything wrong. It's up to the cops to prove their guilt beyond a reasonable doubt. But the assumption is that the prosecutor's right and the defendant's wrong. I mean, we call him the defendant. He's on the bottom end of this arrangement. So one reason for defense lawyers to speak up is to try to balance that playing field overall a little bit, trying to put a little bit more oomph under the defense side and saying, hey, innocent until proven guilty. He walks around free so far. You do not get to make the assumption that anybody involved with an internet cafe is a member of the mafia. That's what the prosecution would like you to think, but there's another side to this story, without getting into any of the details that could potentially cause you problem. The other thing, and this is something that's tough on the newspaper side, and I hate to have to acknowledge it, nobody remembers. The idea of prejudicial publicity, baloney. It just doesn't happen. Look at the OJ case if you want a relatively current example. I can think of one when I was working at the Beacon Journal. Had some kid murder a minister and his wife, orphaning 5 small children. It was about as horrendous a crime as you could possibly imagine. 6 months later, when that kid comes to trial, one prospective juror after another saying, what? What case? No, I don't remember anything about that. It had been in the front page of the newspaper for weeks, and nobody remembered. The idea that somehow, and now this is admittedly before the internet, but the idea that somehow people keep all this stuff stuck in their mind, it's just not true. They just don't pay that much attention. Now it's because of information overload. They just can't keep track of all this stuff that's going on. There are reasons for the defense to speak up, I think, to try and level the playing field. For the journalist side, you know, they'll take whatever anybody gives them. And if they only get from the prosecutor, that's what they'll publish because it's all they've got.
All right, Tim, for just the standard, give us your version of what on the record, off the record, not for attribution. What does that really mean?
There's a line on this list of things that we're going to talk about. One of them is, do I trust you? And the answer to that question really controls everything else. Off the record means you're not going to put my name on it. I don't want to see my name on it. Not necessarily I don't want to see it in the paper or on the news, just don't identify me with it. Now, you can negotiate that with the person you're talking to. All right, you can use this, but don't put my name on it. Or I'm just telling you this so that you'll know it, but you can't use it unless you get it from somebody else. You can't identify me in connection to it. But that really is based upon a trust relationship. I've taught reporters this for years and years and years. Talking to a reporter is an awful lot like how Woody Hayes felt about the forward pass. 3 things can happen to you, 2 of them are bad. Well, as far as talking to a reporter is concerned, from the non-reporter's point of view, all of it's bad. Nothing good will come of talking to a reporter. Chances are they won't get it straight. If they get it straight, they'll spell your name wrong. Yeah, it goes on and on and on. So and that's something reporters have to live with, that people simply do not trust you. And they have ample reason not to. So you got to work at building up the trust and making sure people can rely upon you to get it right, to get it fair, to be accurate, to be straight with it.
Cool. So Jay, the reason I shut you up is because you got to do your number 1. So what is the number 1 thing you hate about journalists?
Well, I think I already got my number 1 and my number 2. But let me just, if I can just finish this.
Go ahead. Go ahead.
Because then you get to what do you do at this point? I mean, I'll tell you the number 1 thing I hate about everybody in the world right now, and that is, in America, there's only one motive left, and that's self-interest, and everybody lies because of it. I mean, we have been trained to do that. You don't have to, this is a pretty educated audience in terms, you don't have to look too far into the national news or the local news to know that. So the lawyers are lying. I mean, we just heard in the other room about how lawyers were calling reporters to tell them things while they're publicly saying we don't want a hearing, but they're feeding information. Reporters, I was involved with 3 kidnapped girls in Cleveland with a family member, and there were literally reporters from national media hiding in my bushes, lying about what they were going to do, came into my office and said they were a client for another person so they could listen. So that's what I hate about everybody, but that's an aside. But about what we're doing now in terms of how we develop this trust and stop hating each other. First of all, talking to a reporter is also like Woody Hayes. This is you got old men up here telling old stories. Because Woody Hayes was a coach before most of you were born. If you just remember, the thing that you can do with reporters and building trust is, and what a lawyer has to do on all terms, not just with reporters, but on all terms, is control the situation. Now, one of the reasons that lawyers don't talk to reporters is they're scared because they can't control the situation. They don't know what's going to come out. What's going to come out in the end. And you can't know what's going to come out ultimately, but you can work on controlling the situation. You do that by these terms of art, and you can really explain the terms of art. You can as a lawyer. I mean, one of the things you do with people you really trust is you'll sit down and talk about the story first. The way I call that, and you guys who are professionals in this, tell me if I'm wrong, is it's on background. It's just I want to talk to you about this, but this doesn't go anywhere but between you and us so we understand each other. I don't care what you call it. I don't care if you first met the reporter for the first time. If you can set those ground rules where you can talk to a reporter back and forth, you get the story between the two of you, not collaborating on what the story is, but so you understand each other's questions and answers, that's the first method of control. Because at that point, as you talk back and forth, you have a feeling for what they want, you have a feeling for what you want to get out, then you can begin to go on the record and the reporter can ask you the questions and you can make the decision as to whether you want to be not named or named. But that kind of control, lawyers don't talk because they're scared usually. That kind of control is possible, isn't it? Tell me if I'm wrong.
Yeah, you set the ground rules, you establish them up front, and then you both stick to the ground rules. That's
Yes, let
most
me ask you
important.
both, I think you'll both concur, that it all starts, it's on the record until somebody sets the ground rules, and you would usually expect the lawyer to say, you're coming in and everything he says is on the record until he says,
Correct.
I want to set the rules. Is that your understanding too, Jay?
That's my understanding too.
Okay.
And every reporter's nightmare is a 10-minute interview followed by, that was all off the record.
And what do you do in those situations? Because,
Oh,
I mean,
my.
there are people who've told me, sorry, you didn't say that, I'm using it. But where does that going to get? Because you're right, maybe you guys are going to get along. So what do you do?
Oh, boy. It depends on a lot of things. Your trust of the lawyer. his trust of you, trying to go back and get it on the record.
Right.
Explain to them why it is important that that information get out and be on the record. It's, like I said, it's a nightmare. But the ground rules, and Jay, some of Jay's and my problems we've had 20 years ago or so was not establishing a ground rule as to the identity of information that got into the newspaper. And we had an incident. I don't want to tell that story.
I
but
do.
That's just
Leave
gonna-
that to them.
There we go.
Because this is a story that actually carries all these things through.
Okay.
The Cleveland State baseball team was accused, literally almost the entire baseball team, almost all young Hispanic men, was accused of a gang rape on a young woman in the dorm. She was highly intoxicated. She was left on her dorm door, and they were vilified as being rapists. And whatever happened, their behavior was totally unacceptable. But the question is, are they rapists and they deserve to be called rapists? They were perp walked in front of cameras. There was vile things said about them. So what happened was, it turns out one of these young jackass men who were involved in this audio taped the whole thing. And the audio tape had tape of the young woman talking about it being consensual. It's all the whole situation is terrible. But we go right where we are in this rule. The young men have been vilified, but now there's hard evidence that maybe they were just guilty of despicable behavior and not rape. So another lawyer in Cleveland, Gordon Friedman, and I, there's about 10 lawyers, but we figure we've got this tape. Now, didn't know exactly where the rules fit, but we're going to give it to Mccarty off the record. But none of us talked about the rules of how we were going to do it, but don't put us in it.
Right.
So, and understand, this is as cogent today as it was when we did it. These exact same things could happen today. It just so happens it was our first story. So we hand him the tape. He writes the story. This is on Friday, I believe. He writes the story on Friday. Gordon and I are doing court on Monday. He writes a story on Friday and writes, here's a tape, here's all it says, it's great for the defense, it works, and it was provided by defense sources. Well, as it turned out to my mind, I don't know if he agrees with this to this day, we're the only two defense sources, me and Gordon, that could possibly have given it to him.
I don't agree with that, but
But here's what happened.
there were
Gordon and I-
12 defense lawyers.
True enough. But here, Gordon and I go into court Monday morning for the pretrial. We're the only two there. The prosecutors, a man and a woman, come around the corner as if they were on a freight train. You know, Cuyahoga County, you're all in the back rooms. They come around the corner, they walk right by us into the judge's chambers, and they shut the door. Now, there's something unethical about that, but it's not for discussion here. They're in there talking, they're harumphing in there. So we walk in, and the judge, he was an old Irish judge, and please excuse this, I'm Irish.
One of the worst. Is he still alive?
I don't know.
I don't
wouldn't
know
say
either.
about
He's
this.
not on the bench, but he was, I think we could all agree, in the bottom 1% of the bench.
Yeah, you got to say something about Cleveland. So anyway, so they call us in. Now, they all know it's us. There's no question. They all know it's us. Whether Jim is right or not, they said, so the judge says, you guys did that, didn't you? And we couldn't lie. You can't lie. And there's an end game to the story, and it's based on that. So what I was saying about Irish judges, did you ever see all Irish judges have a lot of white hair, of which I'm profoundly jealous, obviously, and all white judges go like this. And they rub all that white hair, and he's rubbing his head. And the prosecutors want us in jail for releasing this stuff. They want us held in contempt. And the judge looks up and he says, you know, if it wasn't you two assholes, I'd put you in jail today. And it all blew away. Well, so that's the...
Because there was really nothing wrong with the story.
No, but they were pretty mad that we released it. And
They released all the prosecutorial evidence, and oh, by the way, there's another side to this story, and it was kind of, I don't remember if I quoted the tape or anything. I basically said there's a tape that makes it indicate as if she was consensual, and if I remember right, I can't remember the tape, but
You sound like a defendant.
Yeah.
Oops.
Anyway.
It made it sound like, you know, she was just having fun with the guys, and and she wasn't really that drunk, I think is what I remember it came across. But anyway, but what we didn't have was a guideline, a rule that said, all right, how am I going to refer to you? You know, where did I get this? It didn't just fall out of the sky. I have to say where I got this tape, and that's what we had not talked
Yeah, how was
about.
your guys' next conversation?
There's a second level before we take the question that I have to get out here because I think it's equally important as understanding these rules. And that is, one of the ways you control a situation with reporters and in the aftermath of this stuff is your own personal credibility. You have to have absolute credibility for integrity that you're only doing things for the right reasons. That judge knew inherently that we were doing that to balance the system, to balance what had happened. If you don't have that personal integrity, if you've got the reputation, as I alluded to before, about being a lawyer who's out there on camera in the reporter's notebook because you want to get your name in the paper, you will get hammered for that kind of stuff. And by the way, make no mistake, the camera more so than the reporter's notebook, but they're both aphrodisiacs. Once you start talking, you're going to keep talking. You can't stop.
All right, we'll try to make it move to a different thing. So Jim, give us another thing you don't like.
Okay, let's see. Jay touched on this, but I'm gonna take it the next step. Who fashions the story? Who controls it? It's something that I don't like to be controlled, but I wouldn't have a job or a profession if people didn't want to try to use me as their conduit, as their messenger to the public. So the majority of reporters, I would say that we, the reporters, and I think lawyers, many lawyers would say this, reporters control the story. We're the ones who gather the information and the documents and do the interviewing. And as Jay referred to, lawyers like to take control of the story. So I had lunch the other day with a very, I'll just say, a prominent criminal defense lawyer in Cleveland, whose name will remain anonymous. Imagine that. And I mentioned that I was going to be on this panel and some of the things that I was going to be talking about. And he said, when I told him about controlling the story, he said, of course, that's what we do. We manipulate the media. And then he went on to say, we're both bottom feeders. We need each other to exist, which is kind of a cynical characterization of both of our professions. But I actually agree with that. I mean,
well, and I'll
without
take
each other, you know.
Yeah, that's the whole point of it. Without each other, this gets nowhere because you guys are right on the front lines of stuff that no one else is there to do. You know, so I get it, and I'm going to go through to Tim, then back to Jay on this. But right, it's the idea is, because it's just not lawyers, but of who controls this and manipulation. Because again, you're on campus too. A lot of more powerful balance of power is going to say, this kid isn't going to tell me how the story is. I'm going to tell him how it be. So give me a little bit of your perspective on should reporters not like lawyers or anybody else if they're trying to push them or steer them?
Well, Jim's right in terms of bottom feeding. It's the nature of the business. I have colleagues who discuss mediated communication, which is a term that I didn't know about until after I became a professor, which basically means you go through somebody to get your story out. You can't go directly to your audience. And when you live in that kind of a world, then you want to work real hard to shape that mediator. You want to make sure that the mediator delivers the story that you want to have out. Today, that's much more difficult than it's ever been because lawyers don't need us anymore, us journalists, nearly as much as they used to. They can go directly to the public. You can tweet, you can Facebook, you can email, you can do all kinds of sources that can get to your audience much more quickly and without much of that shaping going on by the journalist. Now, admittedly, the information isn't vetted very well. I've got three younger brothers, and we constantly battle on political issues. I got one other one like me, a bleeding heart liberal, and then two Republican Fruit Loops. And we're constantly at each other's throats over political issues. And the issue is, where are you getting your stuff? You getting that off the Drudge Report? You just lifting it straight from Rush Limbaugh? Well, some of these sources on the internet, for example, don't do any vetting at all. They just simply repeat it from someplace. You can see it with that story about Obama's going to spend $50 billion a day going to India. I mean, that was just a pickup line from someplace, and it got repeated again and again and again. And that's what happens in this business between lawyers and journalists. There are other avenues, and because there are, it makes it that much more difficult for the journalist to try and control this story and verify the information. Because, the hard as this may be to believe, there are occasionally lawyers who wouldn't tell the truth.
I'm going to make one little boring advertisement here. We didn't put a lot in your e-packet on this, but I did put a couple of those rules that lawyers have to abide by so that we aren't brought up with ethical charges, which I think that was Jay was making when he was talking to that judge. Is not only is he trying to win a case, but he's also trying to avoid a disciplinary action for something he didn't think he was doing wrong at the time, but may have appeared. So if you want to look at those rules, I think they're going to be very helpful. Jay, comment on this too, because you were starting to touch on it a bit earlier, is yes, if he's in control of the story and you know that you're only going to get half of it or something, how do you feel? How are you dealing with understanding that? Are you going to let him, is it his story? And if it isn't, you know, there's going to be both sides. How do you weigh that in your practice of talking to reporters?
Okay, first, sorry, but this means a lot to me personally. We are not bottom feeders. Lawyers are not bottom feeders. Reporters are not bottom feeders. I understand that's a nice slick term, but I have told Jim for 25 years, and every reporter, Cleveland used to have, the Justice Center used to have an office right off of the center of the Justice Center. The media is so poor at this point, they didn't even have a God blessed office in the Justice Center.
We don't even have like full-time beat reporters.
But, so there was an office there, and in the office was the James Van Vliet Memorial Couch. Jim Van Vliet was his name, right? Was a big fat guy, and he slept all afternoon. And he slept on that couch. Well, but there was a lot of times when I would go in there and sit and talk to him and everybody else that went. And it's not, and please excuse me for this, I don't mean to preach to you, but we're not bottom feeders. The First Amendment is the most important of all the amendments, and the Sixth ain't too far behind it. So don't think that what we're doing is somehow should be lessened by the fact that it's been coarsened by the Drudge Report or social media or anything else. That being said, then you get the issue of controlling the story. And who controls the story? Well, first, from the lawyer's point of view, and this is a personal opinion, and you guys, I know will disagree if you don't, but you first control the source of the story. The source of the story is where you want the story to come out or what's happening. Now, clearly, people are calling you. You can still control the source. You don't have to talk to everybody. A long time ago, I represented Roseanne Barr's father when she accused him of sex abuse. I got phone calls, 10 a week, because she was the hottest person on earth at that point, 10 a week from media outlets saying they wanted to talk about it. The particular strategy at that point was to pick only one media outlet, which turned out to be 60 Minutes, only one media outlet because of that absolute credibility. Now, I don't get stories, I've had 2 stories like that my whole life. You don't get stories like that where you can pick broadly, but you can pick your media outlets. You don't have to talk to the cheesier TV stations or the cheesier newspapers. You can pick it, and my personal opinion is, while TV is more immediate and you'll get people saying, oh, I saw you last night, it also blows away in the ether. It goes away quicker. Print, I think, is more read by opinion leaders, because we got no print in Cleveland left anymore, but it's more read by opinion leaders, it lasts longer. So you've got that issue of control as to who you're going to talk to. The next issue of control that you have is how you control the story. And this is true whether it's TV or not TV. I don't know, and I'm curious of what you guys think about the idea, and I know you know it happens, where if you're asked a question by a reporter, you can give the answer you want to give no matter what. Because generally it's the answer that's news, especially on TV. It's the answer that's news. They'll never put the question on. More important than that, you can control the story ethically, legitimately, and with the acquiescence of the reporter by the way you fashion your quotes, Don't fall into the aphrodisiac, which I do all the time and I'm doing right now, blathering out to you. Don't fall into the trap of just talking. Devise the quotes in advance that you want to use to build the story. I maintain, tell me if I'm wrong, old friend, that I can build your story with 3 quotes. If I get 3 hot
Absolutely.
quotes.
That makes my job easier, and it's better for you because you are controlling the story perfectly. That's the way. We're just looking for short, pithy quotes.
He is controlling the part of the story you want him to control.
Yes.
His side of it. He's
Yep.
not controlling the whole story. And also, let's go back to when agreeing with you with bottom feeders, I meant that we are at the circumstances, like you just mentioned, we're at the cases of the parts of humanity that the only other people that are really going to be there are journalists and lawyers, let alone, you know, some law enforcement others. There's not a lot of other people there having to address these issues. That's what I kind of, that's So give me another thing you don't like about reporters.
Well, the big thing I don't like about reporters now has nothing to do with personal reporters. It's what's happened to reporting. It's lack of resources in terms of what's happened to reporting. And that is across the board. The nature has changed completely and totally. The nature, please excuse me for this, but as far as I'm concerned, the nature of reporting changed in Woody Allen's movie when Marshall McLuhan, did you see that movie? Old men tell
Right.
old
The
stories.
medium is the message.
Yes,
Yes.
Woody Allen was there. Some guy was pontificating about Marshall McLuhan, and Marshall McLuhan wrote a book, The Medium is the Message. And some guy was pontificating, and Woody Allen, the movie, pulled Marshall McLuhan himself off from behind the side, and he said, "You know nothing of my work." Just to shut up the blowhard.
Right.
Well, the point of it is, the medium is the message, and what's happened is, I mean, we started with TV, which shortened people's attention span. You know, people stopped reading, newspapers sold less and less. Then we went from TV to cable TV, where everything is now in 3-second bits, and another problem with the media now is it's for profit. That's the second thing. It's lack of resources. But now, where it was romantically, CBS News would never talk to CBS Corporate, would never talk to CBS Entertainment. They were totally and separately apart. So the myth goes. That doesn't exist now. All news is now for sale. It's all used to sell the product, to get the ratings. So I hate more than anything about what's happening to all of us. So you get cable news, you get talk radio, you get Cleveland at this point doesn't have, well, we have a 4-day newspaper now. We're a major city, 2 million
4-day
people.
home delivery, yeah.
4-day home delivery, and the rest of it's online. I don't care what you say, and I do it every morning. You can't read as much online. We don't have legitimate media sources where we once did.
And then, so the quality of reporting is suffering. So is kind of your point there, right?
The whole nature of news is reporting, and as a subset, the quality of the reporting.
So I'm going to ask the lawyers here by a show of hands, if a reporter calls you that obviously says, I'm new to this, or I'm new to this subject, would you take a moment to kind of explain the law to them so that they could have some knowledge to ask some knowledgeable questions? Any lawyers that would do that? There we go. Good. Would you, Jay?
Yeah, absolutely. That's exactly what I was talking about with. You sit down, you talk about the story first, you explain it first. The problem is, there's too much gotcha out there, and people don't want to do that.
Well, and another problem is, you know, I've made the offer, open door policy, come in, talk to me if you've got a question about the law. Because I used to be a reporter, I was in your shoes. I don't have time. Or they come in and I'll explain it, you know, I'll point them in the direction of some resources to help them understand the law. They still get it wrong.
Well, you know.
It's like, one of them was about one of them was a story about the grand jury process in general, and I'm going, oh man, there's just so much wrong with this article. And I had to call the editor and said, you really need to talk to your reporter because this is going to get you in trouble.
Okay, great. Before I ask him questions, anybody have a question they'd like to pose to anybody? All right.
I have another pet peeve.
Go.
Most lawyers don't trust their clients. I can name on 1 or 2 hands the number of clients who I have been given access to through the years to talk to me about their case. Usually I'm going through the filter of the lawyer. Well, the lawyer would say, he's just doing his job, you know, he doesn't want this client to mess up his case or her case. But I think ideally the thing the best way to do it would be for me to meet face-to-face with the client, with the lawyer sitting right there. You know, they can hold up their hand and say, I'm sorry, Mr. Mccarty, we can't answer that. Or they turn to their client and say, don't answer that question, or something along those lines, if I'm treading into areas where it would cause problems. There's something that I always keep in the back of my mind. Just a quick aside, I've been sued twice, both times by lawyers. They were both judges. And both times I won, if there's such thing as a winner in a libel case. But I was represented by the Baker and Hostetler law firm in Cleveland. And I saw David Marburger here, so I'm glad he's not in this room. He would probably know who these people are. But I had two fine attorneys who defended me and brought me to a good conclusion. And they told me something before I went into the deposition, which I've always remembered and I've used in my approach to dealing with lawyers and lawsuits, etc. They said, always remember, we are smarter than you are. So I don't know if I agree with that, but I keep that in mind, that that is the mindset that I'm dealing with. So, and that does affect whether, and I think it's that mindset that keeps the lawyers from letting their clients talk to the media.
You know, I'm going to ask Tim to go to this, and then if Jay wants to comment too, but I really think that's an interesting point for you for both sides. The clients speak right to the reporter. I mean, from the reporter's access, I would say, sure, let me, but as a lawyer, I mean, I don't know if I would really be thrilled with that. So what do you think, what are kind of the yin and yang of that offer?
I'll admit my experience as a criminal defense lawyer is far more limited than Jay's, but it's been my experience that my clients will speak the truth to the police or anybody else but me. And so I worry a little bit about letting them talk to a reporter of all people, turning them loose and letting them tell the story to the reporter, particularly if I haven't heard it all yet. It's tough enough to have to hear the rest of the story from the prosecutor while I'm trying to negotiate a deal without having to read it in the paper in the bargain. So I'm not anxious to have my clients, any of my clients, speak directly to a reporter. I'll do the mediation there in terms of that information. I do want to make a correction. Jay's right. We're not bottom feeders, we're sharks. We feed at a higher level, but that's true of both the reporters and lawyers. We circle each other constantly, having to move all these because we can't stay still. But we have sharp teeth on both sides and can inflict some serious damage. So I think it's worthwhile for both sides to be wary of the other. To, I hate to quote Ronald Reagan, but trust but verify.
Yep. So Jay, because you were talking also, I mean, you've talked about cases where people, you know, maybe the best thing for them is their face to be seen, or there's a, what would you say if he said, I want to talk to him, even under your supervision?
Well, let me ask this, because I can't.
Okay.
Because I can't think of it. Can anybody here think of a reason why you would have a client talk to the press? And from the lawyer's point of view.
Go, yeah.
Tell us.
If they seem attractive and they also are articulate.
Yeah, I was thinking if I've got like a 90-year-old little lady who's run up on bad IRS charges, and it's like, this is crazy. You know, if I prefer her that I'd hear from him, I'd like to hear from her. Go ahead.
Is there a distinction between TV and news and newspapers? What do you think?
No, when I was
What?
Yeah, when I was a print reporter, I had a couple attorneys who did let their clients talk to me, and it was a sort of, you know, hey, you know, this person's a individual that, you know, is well known in the community, that sort of thing, articulate, and they were able to talk without torpedoing themselves, so to speak.
I got one way in the back, though. Go ahead.
First of all, I want to thank you for defending the lawyers as to not being bottom feeders.
I'm sorry, I can't hear you.
I said, first of all, thanks for defending us lawyers as not being bottom feeders. I really think that lawyers, at least the ones I practice with, do a lot of charitable things and a lot of good things to get a bad reputation. But on the media thing, it's sad, as I sit here and just listen to you guys, it's sad that we come to this point, we have ethics commissions, and you read the rule 3.6. I was formerly on the ethics commission in West Virginia. And it's sad that we even get to this point, because there's only two reasons that you talk to the press during a case. One is to advance your client's interest, which prejudices the case, which violates the rule. And the second is to advance your own interest. I can't think of another reason why we talk to the press at all during a case. After a case, after the facts have been found by a judge or a jury, that's different. You can comment at that point. There really is no real good reason. And one of the problems that we all have is your ethics commission, our ethics commission in West Virginia, nobody enforces the comments to the press. They're uncontrolled, they affect cases, but there's actually no good reason if you think about it. I can't think of a reason, and you just asked the question, why would you have a client do it? The most recent case I was involved in was the Steubenville rape case, which is one of the reasons I came here to listen. I represented the victim's family, and I was very careful to make sure that no facts were discussed. It was only about women's rights, pretty much, which is a different message, totally different. It doesn't affect the case itself. But in that particular case, one of the lawyers had his client actually give an interview about the facts of the case that was interviewed that became actually subpoenaed during the trial. Now, it wasn't admitted by the judge, but why that happened, and he was a very good lawyer, but he had pre-recorded a statement of his client who didn't testify at the trial. But they had this long tape from 20 minutes that was done. So all these questions that we have, the reality of life today is it's a media source, and lawyers are trying to promote themselves through websites and things like that, but we're all damaging potentially the judicial system itself. And that's the real problem. When we need to get the root of the problem, we need to get to the ethics commissions. When you said this guy, the prosecutor up in Cleveland, made all these statements and things like that, did you report that to the ethics commission? Because you have a duty, just like everybody now in the room, because now we all know about it, have a duty to report that if it was influencing it. But we don't do that because it's natural, it's our friend, it's somebody we're dealing with on a regular basis. You report that guy to the ethics commission, the next 50 clients you got there, you're going to get stonewalled. So you got to be careful. But it really needs to come from our ethics. We need to have tighter rules in our profession about publicity. And we don't. We have all this advertising shit going on right now on the websites and verdicts and things like that. We really need to control that more. And I think that's really where the problem lies right now. We haven't taken active steps to tighten up our rules of professional responsibility.
So I'm going to repeat them because this is being taped, so folks that haven't, then Jay, you can answer. There's a real question of we need to tighten up the ethics rules, or we need to apply the ethics rules as written more stringently, or this stuff happens. Is kind of that was your comment in a nutshell.
We all know that Jay has got
Right.
some kind of handbook. You give it, type out your statement, you make it 3 sentences, you give it to the reporter. He can't misquote you because you got it written down. You're gonna get your quotes in. That's the way to handle it. But people don't do that now. They give these interviews. They start talking, and like you say, it's an aphrodisiac. You just start talking, and you're saying things that maybe you is taken out of context or you don't want to say.
All right,
Why don't we tighten up? Can we tighten up the rules ethically?
Yes, no. I'm trying to think of all the various points you made. Yes, no, yes, no, no. Here's what I think. Obviously, you know the first thing I said is lawyers who speak for their own interests is absolutely unethical. I think your analysis is far too narrow, however, when it comes to speaking in the media. Advancing a client's interest in the media may not necessarily, we've already talked about the idea, it probably isn't going to affect the case at all. But there's 2 separate reasons why you would do it. Number one, there is a world around the client, including the client himself, which needs some sort of vindication because they're the ones who are getting dumped on, even by the idea of an indictment. So that's one level that's wholly legitimate. A second level that's wholly legitimate is the idea of balancing the system. If you were thinking about the Steubenville case, we might have been in the same room just a moment ago, and we kept hearing about how the public has a right to know how the system works. The public has a right to know the system's balanced, and they do. Well, the public also has a right to know that there are, though it's not the technical burden in a criminal case, it is in a civil case, 2 sides to a story. There is a systemic issue to push back, to talk about the idea that, wait a minute, maybe this isn't what you think. As an example, this story, $1.2 million seized in raid, proves that these people are in the mafia. Actually, they were talking about the Arabic mafia at this point. In fact, less than 2 months after this, the state gave all the money back to Mccarty's office, because it wasn't linked to this. So all I'm saying is, I hear you, I understand what you're saying, but it's a more broad world than that. And if we don't push back systemically, that is, people of the less powerful. And understand, it's every bit as important in civil cases as it is in criminal cases. Please excuse me for the editorializing, but tort reform is far more about powerful people controlling access to the courts than it is about lawyers making money, and lawyers are pigs, and that's part of the problem. But nevertheless, there's a systemic reason to comment on these things, and you may just have to do it in the place where you are, which is in the context of a case.
Paul, did you want to?
Yeah, I'll jump in here. I just did want to say to the earlier point, maybe 3.6 does need to be clarified. Maybe it needs to be more solid. But I'm still not sure where that takes us, even if you said that it did. Legally, how is that going to improve adjudications? I'm not sure that it really would. But beyond that, I think there's a big issue here that we're sort of glancing, and that is the dynamics of power. You mentioned the prosecutor comes out and talks. That is a source of power that really hasn't been discussed here, and that is that prosecutor has power with the reporter because the prosecutor continually feeds the reporter, and that reporter needs that prosecutor. So when you turn off your client as a defense attorney or somebody else that might counter the prosecutor, what you're doing is shifting an already loaded table further in the other direction. Because now the reporter doesn't rely on that defense attorney or the attorney that's balancing the prosecutor out because he's not there. So you've really just cut your own throat as an attorney or on that side of the bar, because now you've given the prosecutor who has a ton of power in public perception even more power.
Well, and he also has, and there's another rule in there when you get to him on the powers and the roles of prosecutors. So take a look at 3.8 when you get a chance too. Tim, do you want to comment that? Because it's interesting, the prosecutor is also elected. You know, he's got in his mind also a duty to kind of articulate this to his constituents. You know, he's accountable. So a little bit about this power struggle too. What should prosecutors be doing? Do they cut their own throats if they don't respond to the prosecutor? And is it fair to the public to know more from one side or less? Or is it fair? Do they have a right to know both sides before the jury or before we even have a case?
Well, in the interest of full disclosure, as I said before, I'm a defense lawyer. So I come at this from a prejudiced point of view. The prosecutor basically has the power. The prosecutor has all the authority of the state. The prosecutor has all the investigative help. The prosecutor has all the forensic help. Depending on who your client happens to be on the defense side, you probably have very little going on your side, and the prosecutor has most of it on his or her side. And they use that. I can't blame them for it. That's part of their job. They're required by law to protect the public from miscreants, and I'm required by law to defend those people. But it doesn't make for an even playing field. Some prosecutors are a little bit more heavy-handed about this than others, particularly those who are in tight races, those who are worried about re-election. The prosecutor in my county hasn't been opposed the last 3 elections. He could run upside down and nobody would care. And yet, he is the source of 95% of all stories that appear in the local newspaper. They don't even bother to call up the defense side on stories. They just simply report whatever the prosecutor tells them. And since they do, and he's the primary source, I don't imagine he sees any particular problem with that. But it does create a perception in the public's mind that anybody who gets arrested is guilty of something. And that's unfortunate. I don't blame the prosecutor for it. He's doing what comes naturally and what's available to him.
I think 3:30 is when we're supposed to end, correct?
I don't know.
No? Did anybody?
3:45?
We got 15 more minutes? Good. Do you want to ask, I want to ask you, do you like being told you're wrong by an attorney? And attorneys too, do you want to be told you're lying?
No, that's another thing we hate.
Go ahead. Yeah, this is, I thought we'd switch up another question.
We like being educated, as you know, we referred to earlier about the law and about I mean, sometimes I'll pick up a document, a brief, and there will be all this information in there, and I'm saying, oh my God, either my eyes glaze over or I start pulling my hair out because there's no way I understand what this is about. And I really appreciate it when a lawyer will walk me through it and say, okay, this is the background information on that, or this is something you need to know to help explain what you're reading there. So no, we like to be educated. We don't like to be told, you're wrong, you did a rotten story, it wasn't fair, you know, because every reporter I know, and myself included, bend over backwards to be fair, whether we like the person in our story or not. I mean, I write some of the best stories about people I personally don't like. I mean, there's a judge in Cuyahoga County who, I think, Shirley Strickland Saffold. She's had her ups and downs through the years. I didn't write it, but she came to me after she felt burned about a statement that she told a defendant, a woman, in a nutshell, to go to Case Western Reserve.
The clinic, outside the clinic.
Yes, outside the Cleveland Clinic. Just sit there and cross your legs, and maybe you'll meet a nice, you know.
She actually said when the young doctors walk by,
Young doctor,
recross your legs
yes.
and maybe just open them a little bit and you'll catch a doctor.
Oh, boy.
Honest
Yes.
to God, she said.
So that was,
Is that
yes.
any exaggeration?
No, it's not. I didn't write that story. So, but from that point on, whenever Shirley found herself back in the news, they would send me in there because I was the only reporter who she would talk to. Well, it turns out that was not her biggest problem. During the Sowell case,
Right.
there were, you know, he killed, what, 12 women?
More than that, I think, didn't he?
It was, anyway,
A lot.
killed many women. It was a huge case. She had that case originally. And the reason she lost that case was throughout the process of her having that case and it kind of moving its way toward trial, she was going on Cleveland.com and logging her comments about the defense lawyer being a dumb step-and-fetch-it type, racist thing. She is black, and she's using racist terms to describe the defense lawyer and other things. I mean, basically, we tracked her comments online, and they're way off the wall and not good. So she had to, she sued the plain dealer. That was the second time I was sued. That was $50 million she sued the plain dealer.
Because she
for.
said her daughter did it, right? She said her
Yes.
daughter
Yes.
entered the comments.
And I
under
actually
her name.
interviewed her daughter.
Okay.
And I think this is one of the few, one of the 5 times in my career that the daughter's lawyer gave me her cell number, and I called the daughter. And basically, if he hadn't have done that, I wouldn't have known that the daughter had nothing to do with it.
Oh.
She was down in Columbus. She was a student at Capitol Law School at the time, and I asked her questions about. It was a 3-way call. So the lawyer was on one line, she was on another in a different city, and me, and the lawyer had to stop it because it was clear from the start that she had no idea some of the things that her mother was saying she was commenting on. I mean, she didn't know what the issues were. So anyway, that gets to the point where, I mean, that's where I'm coming from. There, that's a worst case scenario.
I'm going to ask Jay to articulate to this too. So if a reporter, not Jim, gets something wrong, how would you approach that in your best way to get it right, or whatever you want? What do you want to have happen next? Actually, what if a reporter gets it wrong? What do you want to have happen?
Well, in my experience, I have never asked for a retraction or done anything like that. I made a giant mistake once because in a story, nothing related to Jim, in a story, I think personally, I believe I was intentionally misquoted, and it changed the whole tenor of the story and the headline, and I regret to this day I never sued the newspaper. So my answer is, I've never done anything except try to build a relationship of trust. Because if you don't, it's like you're giving a closing argument in a case. If you've given the argument and you made a mistake, and we all done it, anybody who's ever tried a case knows you forget one or two things in every trial, but once it's gone, it's gone. So yes, I suppose there's mechanisms. It's merely a matter of being better at it next time. So I'm a bad one at it because I've mucked it up in my time.
Well, we probably not asked him. I mean, it sounds like maybe you would not talk to that person again, or the next time you talk to him. Okay.
You have to have, what we haven't talked about here, and we did a little bit when I was joking about the couch, you need an ongoing relationship with the reporters in your life, in your cases. You need to talk to them. You need to get to them. Now, that's harder and harder now because it's so splintered. Now, Jim has had 2 spectacular jobs recently. He works in the federal courthouse. Nobody works a lot in the federal courthouse now that the government shut down. Nobody's been working at all. But he's got an office right there with a glass door right by the elevator.
Great.
You talk about one of the great gossip spots in America. Everybody goes by. Everybody wants to talk to him. And his second job is even better. He is the Cleveland Plain Dealers bird watching reporter. And he flies all over the world to watch birds. And better than that, he has a rich friend who has a private jet, and they go first class, who flies with him all over the world.
True, all true. It's a tax deduction. They pay me, the plain dealer pays me a nominal fee. I do it on my own time.
Ongoing relationship is necessary, and just like any interpersonal relationship, there are going to be things that are screwed up that you got to overlook or you got to work your way through.
Tim, tell us the best way if you mess up to go back, and your best way if somebody's gotten you wrong. How would you approach that?
I told reporters for years, you make a mistake, admit it right away, thoroughly, completely. Don't cavil, don't weasel word it, don't try to squirm out of it. If you've made a mistake, just simply say so. Now, you've eliminated truth as a defense if you're going to get sued, but that's okay, because readers understand when you're getting a half-hearted retraction. If you've made a mistake, just say so. Everybody makes mistakes, and when you print as much as a newspaper does, or a broadcaster for that matter, you're going to get things wrong from time to time. I would tell people on the other side, people who are complaining about this, don't talk to the reporter who made the mistake, because inevitably they get defensive. Inevitably they want to argue about it. Inevitably, well, that's not exactly what I meant, or you're reading something into this, or that is what you said. Talk to the boss. Go to the top. It saves you a lot of time and trouble. And explain your situation. Now, one thing more that I would mention in this area, if somebody made a mistake, you can call them on it. There's nothing wrong. Demanding a retraction, what you're going to get is whatever the original mistake was repeated. If you're lucky, they may straighten it out, but chances are it's going to be as bad the second time as it was the first time, and now you're going to have the mistake repeated. Think long and hard about how badly do you want this thing fixed in the paper as opposed to just fixed in the record. Just make a fix in the file someplace, make a notation so you don't repeat that again. But think long and hard about whether you want a retraction.
Yeah, and I would think, just in your experience, and what's been in mine, it's never going to be comfortable when a reporter you have to work with every day gets it wrong, and I'm not going to ask for a retraction, but I'm going to have this conversation about how it was wrong, but we want to work through this. We got to get past it, even though I went to the boss and told them they got it wrong. And on the other side, too, if you mess it up, you want to get their trust back. So it's not going to be pretty. It's going to be a relationship.
That's good advice, Tim, and it's 100% accurate. One of the things, there are very few benefits to the new media online. The first appearance of a story these days is online before it gets into the hard copy paper, and I really appreciate it when people see a mistake online and call me. I mean, those have spared me from bigger mistakes. I can't count the number of times. We appreciate it. Thank you. I'll fix it. We can just go right into the blog, fix the mistake, and republish it. And it's not as if it didn't happen, but it keeps it from being a bigger problem.
Audience, peeves or questions you guys have that you want them to address? Go ahead.
Quick question. If a news entity learns that they made an error, even if accidental, why would they refrain from saying, oops, we made this mistake? We said X and it's really Y.
Very good point. What if the newspaper makes a mistake, or the publication media outlet makes a mistake and knows the answer and refrains from doing it? Any idea of why or how if they do that?
It's like Tim said, you know, we don't like to be challenged. We don't like to be told we're wrong, even if we are wrong. We you know, we get defensive. It's human nature.
There's no reason from the media standpoint not to do it. If we make mistakes, when I was an editor, I was perfectly willing to admit them and put it in print. Yeah, we were wrong. It was not that.
And as a father of a deceased child, and you print on the front page of the newspaper that my child was engaged in gunfire with the police, he and all his companions were unarmed, do you have any idea how that makes me feel when you sit there and know that it's wrong and you don't say, oops, we made a mistake?
Well, if we knew it was wrong, we would most assuredly correct it.
But
You learned after the fact.
Gotcha.
Jailhouse interviews with someone who's kind of a sensational sort of suspect before the person's ever arraigned, but after they've invoked their right to counsel to police. The media goes in, talks directly to that person, and they get a confession on camera.
Wow.
That's my biggest peeve.
Wow. So, anybody had that experience?
I have.
Well, no. I mean, I got it. I mean, what you could do? I don't think there's undoing it. I mean.
Yeah.
I don't think there is undoing.
Yeah, I mean, to me,
As a lawyer, that's a peeve, is what you're saying.
As a
Because a
lawyer, that's
reporter,
peeve.
that's not a peeve, right?
As a reporter, yeah, it's a hell of a scoop, but I mean, you're just basically, you know, giving either the prosecutor or the defendant a, change of venue in a small county.
I've never had that happen to me.
Well, yeah, but that's Cuyahoga County, not a county of 40,000 people.
Yeah, we cover 7 counties, but you're right.
That's an issue of journalistic ethics, I suggest. That I mean, we all have to self-police. I'm not so sure. Again, it's not my experience either. I think that generally, and I don't know. I mean, you teach. In journalistic ethics, is that something you should be doing? Because you can't unring the bell.
No.
I'll do it in a minute. If somebody's arrested and they haven't talked to an attorney, it's not my obligation as a reporter to tell them that they should not talk about what's on their heart. I'm sorry, that's what my job is as a reporter.
Yeah. Just one quick aside. I did talk to the parents of a guy, of a kid. I think he was like 17, 18 years old. He and this other, his friend, were both convicted of kidnapping, raping, and killing a woman in Parma. Remember the Parma Town Mall case? Yeah. Anyway, as soon as they arrested those kids, I think they were both juveniles, but they were tried as adults. I went and talked to the parents of one of the kids who was working. They were both working at a fast food restaurant, an Arby's or something, right across the street from the Parma Town Mall, where their son had worked with them, and they were giving me information that later led to that backed up his guiltiness.
Wow. Well, go ahead. Last word.
Was a juvenile. Did you do it? But all I'm saying is that there are some boundaries there. Yeah. And I'm not so sure systemically it necessarily is good for everybody that if we start letting reporters into the jail always, because you're going to get all kinds of funky stories.
Well, they have all kinds of different.
But I hear you.
My problem is that in that case, the news outlet is making themselves part of the story.
Oh, and I got that too. That is a peeve too. News outlets become part of the story. But we'll have to do that next year. I thank you all. This was a pleasure, and I thank these panelists and give them a big hand for coming tonight.